gotten your head around different requirements for constituting a trust, what the rest of this chapter focuses on is what happens when that attempt at constitution goes wrong. And the basic rule is that, too bad. If you don't constitute your trust properly, or you don't give away your property properly, then the law isn't going to help you and equity isn't going to help you. And this was set down in Milroy and Lord, which was a case in the 1800s. And what they said is that equity was not a sister volunteer. And it's worth, when seeking to understand these cases, just having a think about what that maxim means. Equity will not assist a volunteer. And if you think about what equity is, and go all the way back to the first sort of set of videos that I did, we talked about what the history of equity was and what the purpose of equity was. And the purpose of equity is to treat as done what ought to be done. It's to deliver forms of justice where the law is unable to do so. Discretion, it's a discretionary power. We talk about equity or certain types of estoppel being a shield, not a sword. It's not something you can use to actively do something. It's equity, it defends where it is right and it's just to put up that defense. So you see that with promissory estoppel in contract. What it means when equity will not assist a volunteer is essentially saying, well, it is an equity's job to go in and help someone who's just tried to do something and failed. If there's no other reason and there's no other justification for equity to get involved, equity's not going to get involved. And that was basically the idea in Milroy and Lord. There's no reason to say that what wasn't done ought to have been done. So in Milroy and Lord, what happened was a man tried to give his shares to his niece. He gave them to an agent, or he gave paperwork, or he told his agent to go and I can't quite remember. I think it was shares in the Louisiana bank, and he told his agent, Mr. Lord, to do something that would transfer the shares to his niece, or to hold them on trust for his niece. This was never done. The niece then comes to the court and says, well, these shares are mine, or they are held beneficially for me, and there should be recognised that there's a trust of these shares for me. And the court says, no, your uncle just didn't manage to transfer them properly. There isn't anything here that equity needs to be recognising. In justice, it was just a mistake, and that's not what equity is here for. It's an interesting question to ask yourself, and it's something that obviously the subject guide is asking as well, whether all of these exceptions that we're about to go through, are they really necessary? Do they really add something to the law of equity? Or are they situations where a sympathetic claimant has come before a judge and the judge has tried to twist and make small distinctions within equity to try and get that claimant a particular result? And I think the answer is probably yes. That's my opinion. You should think about whether or not you want to argue something like that in an essay question. You need to look at the commentary, you need to look at the textbooks, and a lot of them will give you justifications as to why this particular situation, and we're going to talk through the situations, or why this particular rule makes this exception to the idea that equity will not assist a volunteer, because there is another element involved that makes it right for equity to jump in and essentially act as this shield to create justice. Remember, just as a point of general principle, it's normally easier to defend the law than it is to attack it. You need to you'll show that you understand both sides in an essay. But if you're going to write an essay either defending or criticising the law, it's normally easier to defend the law, because the judges and the judgments and the commentary will probably have already given you the reasons why this particular rule needs to be the exception, and so to say it's all consistent. So just remember that as a general principle, not in your legal thinking, but perhaps in your exam technique.